Most of us are aware of the Fourth Amendment's unreasonable search and seizure clause. While definitions of what is reasonable have been argued since the Bill of Rights was ratified, it is pretty much agreed that the Fourth Amendment's prohibition against unreasonable searches and seizures includes the use of unreasonable force during an encounter with law enforcement. What responsibility does law enforcement have in the initiation and escalation of a dangerous, possibly life-threatening situation? Well, that was the question in the case Barnes versus Felix, which we'll look at next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. I'm glad you could join me today. This case came up because it involves the use of lethal force by an officer against a civilian. And the question was it reasonable? The question before the Supreme Court was what standard to use to judge reasonableness, but we'll get into more of that as I get into the analysis. Now, if you want to find out more, please go to the website, constitutionstudy.com. You can find the article with all the links to the resources I used to put this analysis together. I'll talk more about the website and other things at the end of the episode, but for now, let's get into this case of Barnes versus Felix. In the case before the Supreme Court of Barnes versus Felix, the question is not so much what is reasonable, but what evidence can the court consider when it determines reasonableness. The Fourth Amendment prohibits a police officer from using unreasonable force. This court held that unreasonable depends on the totality of circumstances. But four circuits, the 2nd, 4th, 5th, and 8th, cabin Graham. Those circuits evaluate whether a Fourth Amendment violation occurred under the moment of threat doctrine, which evaluates the reasonableness of an officer's action only in the narrow window when the officer's safety was threatened, and not based on events that precede the moment of the threat. In contrast, 8 circuits, the 1st, 3rd, 6th, 7th, 9th, 10th, 11th, and D.C. circuits, reject the moment of threat doctrine and follow the totality of the circumstances approach, including evaluating the officer's actions leading up to the use of force. What standards should be used to evaluate law enforcement's contribution to a situation where force may be warranted? The question of use of force has been of particular interest to me for many years. In every state in the Union, a person has the right to use lethal force when there is an imminent threat of death or serious bodily injury to themselves or another innocent party. The one exception to that general rule is the person using lethal force cannot have initiated or escalated the situation that led to the threat. On an April afternoon in 2016, Ashton Barnes was driving his girlfriend's rental car on the Sam Houston Tollway outside of Houston, Texas. That same afternoon, Officer Roberto Felix Jr. was patrolling for toll violations. Through no fault of Barnes, there were toll violations associated with the rental car's license plate, and Felix initiated a traffic stop. Felix asked Barnes for his license and the rental car's insurance paperwork. Barnes indicated that the paperwork may be in the trunk, and Felix instructed Barnes to get out of the vehicle. A dash camera recorded what happened next. The car starts moving slowly forward, and Officer Felix jumps onto the door sill of the vehicle. In the same instant, Officer Felix begins shooting inside the vehicle, striking Barnes twice. Officer Felix then holds Barnes at gunpoint until he bleeds to death in the rental car. The question before the court is not, was the stop reasonable, or even was the officer's shooting reasonable, but what evidence should the courts look at to establish said reasonableness? Oral argument started with Mr. Zielinski, attorney for Ms. Janice Hughes Barnes, and the estate of her late son, Ashton.
Mr. Chief Justice, and may it please the court, we are here today because Ashton Barnes was shot and killed on the side of a Texas highway after being pulled over for unpaid tolls. The question before this court is how to determine whether Ashton's Fourth Amendment rights were violated. The Fourth Amendment prohibits unreasonable seizures. Justice Scalia was no fan of a totality of the circumstances test, but in Scott, Justice Scalia made clear that courts must slosh through the fact-bound morass of reasonableness. In this case, the District Court and the Fifth Circuit didn't do that. Instead, they applied the moment of the threat doctrine. According to the Fifth Circuit decision below, quote, "We may only ask whether Officer Felix was in danger at the moment of the threat, and, quote, any of the officer's actions leading up to the shooting are not relevant." This kind of legal amnesia is incompatible with precedent, conflicts with common law, and defies common sense.
How do we determine if Officer Felix's actions were reasonable? Was it simply that at the instant he started shooting, his life was in danger? Or should the courts consider the officer's actions, including jumping onto the sill of the vehicle, when it considers the reasonableness of his actions? The two doctrines the court talks about are moment of threat and totality of the circumstances. The Fifth Circuit applied the moment of threat doctrine, meaning they gave no consideration to how Officer Felix's actions may have contributed to the threat he felt at the time he used lethal force. While both the district and circuit courts found the actions of Officer Felix reasonable, at least one of the judges wrote in his concurrence that the officer acted unreasonably.
Finally, as Judge Higginbotham underscored in his concurrence, the facts show that Officer Felix acted unreasonably. But this is a court of review, not of first view. The court should rule for petitioner on the sole question presented and remand for the lower courts to apply the correct constitutional standard. I welcome this court's questions.
Now, after his opening statement, Mr. Zielinski answered questions from the justices.
Under your approach, what would that correct standard look like, and how would it be applied here?
Justice Thomas, we think the standard is the totality of the circumstances standard that this court articulated in Graham, Garner, Scott, and Plumhoff. In this particular case, it would require looking at more than just the 2 seconds in which Officer Felix was on the moving vehicle. It would require asking, was there a reason for Officer Felix?
You will find this 2-second rule referred to often in this case. It's related to the time frame in which Officer Felix jumped onto the moving vehicle and him discharging his weapon. Do you only consider the situation when Officer Felix is standing on the vehicle, or the situation that put him there?
How much more than the last 2 seconds?
Justice Thomas, if you include an extra 3 seconds, then you would look at the seizure in its totality. I think that this court shouldn't be drawing bright-line rules on exactly how much of the seizure should or shouldn't come in. That's what Justice Scalia underscored in Scott. There are no rigid rules, and courts can apply ordinary principles of relevancy and proximate cause to determine the reasonableness of a seizure.
So the plaintiffs weren't looking for a bright-line rule, meaning you can look back 2 seconds, or 5, or 10, or 30, etc. Rather, they wanted the courts to look at the relevancy and proximity of the cause to determine if the action of law enforcement was relevant.
Was it reasonable for the officer to jump on the side of the car?
So, Justice Kavanaugh, we don't think it was in this particular case, but that's precisely the issue that the lower courts couldn't evaluate, because they applied this legal amnesia and only look at the fact that the officer was on the moving vehicle. Judge Higginbotham, in his concurrence, looked at the totality of the circumstances and said, I think it was unreasonable in this case. We want the opportunity for a court to be able to look at that and for us to be able to litigate that court claim.
I noticed during oral argument that justices frequently detoured from the question at hand. Should the court have used the moment of threat or the totality of circumstance standard to evaluate the reasonableness of the officer's actions? It seems the justices were very interested in whether or not Officer Felix's actions were reasonable. Mr. Zielinski was not the only person to attempt to bring the justices back to the question at hand. This really isn't a surprise, since the topic of what is reasonable is so often argued in court.
The reason for the question is to probe whether you are using the term unreasonable in a sense that's different from the sense in which the Fourth Amendment prohibits unreasonable searches and seizures. So unreasonable has a particular meaning when the court has to decide whether there was a Fourth Amendment violation. But in lay speech, unreasonable could go to whether the action was prudent, whether it was a violation of best police practices or the practices of a particular police department. Those are not necessarily the same thing. In fact, it seems that they're probably different. So you are eliding these two different meanings of reasonable. Now, maybe that's Maybe that's sound, maybe that's unsound.
Justice Alito, what we're asking for is the standard that this court has applied in Garner, Graham, and Scott and Plumhoff, which is you have to look at the balance here. There's on the one side the state interest in seizing someone in a particular manner. On the other side, there's the harm to the suspect. Here, the ultimate harm, the loss of his life. The problem in this case is that the Fifth Circuit couldn't engage in that core balancing because it couldn't ask, was there a really pressing reason for an officer to jump onto a car and give himself no other opportunity but to shoot the driver?
Was it reasonable for the officer to jump on the sill of the car or not? Did Officer Felix take an otherwise simple traffic stop and escalate it by putting himself in a situation where deadly force was the only option? Well, that is a very interesting question. The argument Mr. Zielinski is making is that the Fifth Circuit could not ask this question because they felt bound to the moment of threat doctrine.
Well, would you be satisfied with a narrow holding that it is wrong for a court to look just at the moment of the threat, that the court has to judge the reasonableness of the alleged unreasonable seizure based on taking into account, to whatever extent they are relevant, the events that occurred before that? Would you be satisfied if we just did that?
I think we would.
Not get into these other more difficult questions.
100%. I think it would be helpful if the court makes clear that that means that you can look at the jump in addition to the shoot, right? That's the core issue that we want to be able to litigate. But yes, Justice Alito, we'd be happy with a very narrow holding.
All Mr. Zielinski and his clients were asking for was an instruction from the Supreme Court that only looking at the moment of threat was not sufficient for determining reasonableness. Other attorneys would make grander claims, but they just wanted the circuit court's decision vacated and remanded to be decided on more than just the moment of threat.
I think you've given up in your reply brief, I understood, that you're not asking us to address the question of what an officer-created danger rule is like.
We're not asking for an officer-created danger test at all.
And that wasn't even addressed below, correct?
That's correct.
Okay.
One of the oft-repeated points was a question of officer-created danger, meaning that if the officer created the danger, it was not reasonable for him to use said danger as justification for the use of force. But isn't that the exact same standard used in every state law regarding the use of lethal force in self-defense? If I cannot create a dangerous situation, then claim self-defense, why should law enforcement? As I said, the justices spent a lot of time on the question of reasonableness rather than the standard for determining reasonableness, which led to this interchange between Justice Kavanaugh and Mr. Zielinski.
When an officer jumps on the car, the deadly force can be avoided by the driver, too.
Well, in this particular case, Officer Felix's own expert testifies that Officer Felix shot so quickly, Ashton Barnes didn't have time to stop. And if I could, let me sketch out, Justice Kavanaugh, why it's so dangerous for you to shoot a driver. In fact, I'm not aware of any police department that recommends that its officers shoot drivers. The high likelihood, in this particular case, Ashton Barnes didn't immediately die. He was able to brake the car and put it into park. If he had been immediately killed, that car could have careened and crashed into the highway. Officer Felix put other people on that highway in grave, very serious danger that particular day. So I don't think it's just he's jumping on to stop Ashton from getting away. He's also jumping on in a manner that is going to put a lot of other people at risk.
Again, not germane to the topic before the court, but an interesting question. Is it reasonable to shoot the driver of a moving motor vehicle? I'm sure there are times when it is, but this seems to not only be an escalation against Mr. Barnes, but a threat to the public at large. Based on research that Mr. Zielinski brought, jumping on a moving vehicle isn't the only dangerous action repeatedly taken by law enforcement.
The other reoccurring fact pattern is a pattern where officers fail to identify themselves, and the suspect, exercising his or her own Second Amendment rights to self-defense, pulls out a firearm. The Fifth Circuit alone has 2 cases in which they apply the moment of the threat doctrine. The cases are Cass and Royal, and they say, we can't look at the fact that the officer failed to identify himself. We can only look at the fact that the officer faced a loaded gun.
Imagine someone comes to your door or your vehicle or just stops you on the street. Maybe they're armed. Maybe they're just demanding information or that you take a certain action. This could easily be seen as a threat, leading you to defend yourself by showing or possibly drawing your firearm. Since it appears most law enforcement is trained to draw and prepare to fire at the word gun, this could easily end up badly for you. Now imagine the court only looks at the fact that the unidentified officer saw a firearm and not the fact that the officer initiated, even escalated the situation to one of deadly impact. That's what we're talking about here.
What do you do with the cases cited by the other side where the Fifth Circuit does appear not to apply the moment of threat doctrine and does take into account more of the totality of circumstances?
So, Justice Sotomayor, let me give you three responses. First, there's never a Fifth Circuit case where they actually look at the officer's prior conduct and say that's part of the calculus and it goes against the officer. So it's always, whenever they might do it, it's only in the officer's benefit. The second, the best case...
Some of my colleagues might agree with that. Why should we not?
Because you have to look reasonableness. The framers gave us a test of reasonableness, and that is it's a two-way street, not a one-way ratchet.
In the Fifth Circuit, there has never been a case determined by totality of the circumstances that did not benefit the officer. And Justice Sotomayor asked why her colleagues shouldn't agree with that. Are you telling me that law enforcement has never escalated a situation into the use of force? Or does Justice Sotomayor believe her colleagues agree with her that law enforcement is never responsible for the use of force, even if they've initiated the situation that led to it? Next to offer arguments was Ms. Zoe Jacoby, Assistant to the Solicitor General. She was representing the Department of Justice, who agreed with the petitioner's position.
Mr. Chief Justice, and may it please the Court, the Fifth Circuit analyzed this case by examining only the so-called moment of the threat and categorically ignoring all prior events. None of the parties defends that approach. That is because reasonableness is assessed under the totality of the circumstances, and pre-force events can be critical to that assessment. Prior events often show that the force was reasonable. For example, police may have issued warnings or attempted de-escalation, all of which a split-second moment of the threat doctrine misses. Of course, when officers face a moment of danger, that is by far the most important factor under Graham. But in rare cases, a moment of danger doesn't tell the whole story. If the danger was manufactured entirely by police conduct outside the bounds of reasonable behavior and not by the suspect's intervening apparent misconduct, it is unreasonable to use force in the moment. The panel's approach fails to provide a constitutional backstop in those cases, and it disregards context that may show that force was reasonable in others. I welcome the Court's questions.
I think Ms. Jacoby's argument is both succinct and convincing. Yes, what happens before the moment of threat puts the threat in context. Did the officer escalate or de-escalate the situation? Was it the actions of the accused or of the officer who initiated the moment of danger? Were the actions of law enforcement reasonable or not? This is what needs to be considered when determining the reasonableness of the actions of law enforcement. Next to argue is Charles McLeod on behalf of the respondents, Roberto Felix Jr. and the County of Harris, Texas.
Thank you, Mr. Chief Justice, and may it please the Court. When an officer doing his duty confronts a threat to his safety or the safety of others, it is reasonable for that officer to use force to end that threat. That's the conclusion this Court has consistently reached, and that's what the Fifth Circuit correctly held below. At the moment Sergeant Felix used force, he was clinging to the side of a fleeing suspect's car, and Felix reasonably believed that his life was in imminent danger. That conclusion should end this case.
Yes, in general, an officer has a reasonable authority to use force in response to a threat to his safety. But does that include when it is the officer who put himself in danger?
Petitioner's contrary argument attacks straw man. Let me be very clear. We are defending the decision below and the moment of threat doctrine as it actually exists. The core premise of that doctrine is that an officer doesn't lose his right to defend himself just because he made a mistake at an earlier point in time.
In this case, the straw man is not being presented by the petitioners, but by the respondents. It was never a question of whether or not Officer Felix made a mistake, but whether or not he put himself in danger and used that as an excuse to execute a suspect he was investigating. Yes, execute. But of the facts I've found so far, no one has been able to determine if Mr. Barnes' actions were malicious or merely accidental. Was Mr. Barnes attempting to evade paying tolls that he had accrued to the rental car before he rented it? Or was it a simple mishap where he attempted to get out of the car at the officer's request, but failed to put the vehicle in park? We'll probably never know.
But applying that rule does not require courts to ignore everything that occurred prior to the use of force. Like other circuits, the Fifth Circuit has repeatedly held that preceding events are relevant to the extent they inform the officer's perception of the danger that he faced. The panel decision below repeatedly cited to and quoted from those very precedents. The panel did not and could not overrule them sub silentio. Petitioner asked the court to create a new breed of constitutional tort, under which an officer facing the barrel of a gun loses his right to defend himself if he previously used bad tactics or poor planning.
Again, this straw man of bad tactics or poor training is used. We're not talking about a situation where an officer parked his vehicle in the wrong place or whether or not he forgot to bring a pen with him. Officer Felix is accused of jumping onto a moving vehicle and using that as an excuse to take another man's life.
That's contrary to precedent and common sense. Graham asks only whether an officer's use of force was reasonable in the particular circumstances he faced. It requires courts to put themselves in the shoes of the officer who used force, not to second-guess every decision the officer made in some of the most stressful circumstances imaginable.
I'm not sure about precedent, but what is contrary to common sense is to believe that a law enforcement officer holds absolutely no responsibility when he or she contributes to a dangerous situation. This seems to be at the heart of Mr. McLeod's argument.
And Plumhoff and Mendez rejected similar officer-created danger theories as illogical, unwarranted, and inconsistent with precedent. The court should reject the theory again in this case and affirm the judgment of the Court of Appeals. I welcome the court's questions.
Under Mr. McLeod's theory, officers can create all forms of danger without any reasonable cause to do so, yet cannot be held accountable. Does that sound reasonable to you? Should an officer be able to stop you and ask you questions at gunpoint? After all, that is an officer-created danger without reason. Since the officer in that circumstance was in imminent threat of death or serious bodily harm, and the accused had not initiated or escalated the situation, wouldn't they have the right to use deadly force to protect themselves from the officer that created the dangerous situation?
How would you assess the difference between the Fifth Circuit's approach, which you as youth see it, and the totality of the circumstances approach as we heard it this morning?
So I don't think that there is any difference between what the Fifth Circuit does and what Graham directs. Both.
No, I mean as what the Solicitor General and petitioners, as they see the totality of the circumstances, not so much Graham.
So the difference, I think, between our position and somewhat the government's position is they want to include within the totality of the circumstances arguments that the officer escalated the danger or created the danger. And we think that that is now a relevant consideration under Graham and under the Fourth Amendment. In those cases, the question is, was there a legitimate threat that the officer is responding?
In other words, Mr. McLeod seems to believe that law enforcement officers should have absolute immunity for any danger to the public they create. I wonder if Mr. McLeod would still hold to that argument. If law enforcement broke down his door, entered his home in the middle of the night with weapons drawn, would he still find the officer-created danger not relevant? Much of the interactions between Mr. McLeod and the justices seem to me to be him trying to skirt around this basic fact. Mr. McLeod's position is to ensure that police do not have the same burden of reasonableness as the average citizen. After all, any citizen on the street that uses deadly force in self-defense must also show that they did not initiate or escalate the situation which led to the threat against them. Although Mr. McLeod likes to refer to the officer making a mistake, bad tactics, or poor planning, what he repeatedly pointed out in his response to the justice's questions was he did not want to consider if the officer had contributed or initiated the danger that he was in. Just look at this interchange between Mr. McLeod and Justice Sotomayor.
If your answer had been if he had walked up in an unmarked car in plain clothes with a gun drawn, and this person and he walked up to the car and this person took off or accelerated slightly and he jumped on and shot blindly, do you think that's reasonable?
I think that would not be reasonable.
All right, so you've given the game away because at that point you have to look at what the officer did.
And, Your Honor, we agree that you can look at what the officer did, and the Fifth Circuit does look at what the officer did. The best example I can give you—
It didn't in this case.
In this case, that's because the only argument that petitioner made below, the only action she said you should look at, was an action based on officer.
And we have three judges who said we shouldn't be limited in this way in the mine run of cases, and so we're stuck with this. We think the judgment is right, but it wasn't addressed at all. Officer-created danger wasn't addressed, and the other side says clearly it's not raising it here.
Did Mr. McLeod actually say that courts can look at an officer's actions, but not if the action was based on officer-created danger? Yes, he did. I guess Justice Sotomayor was correct. Mr. McLeod did give away the game.
So you can still look to things that the officer did prior to using force, but you cannot blame the officer for creating a bad situation and second-guess all of the decisions he made.
I don't believe anyone was trying to second-guess all of the decisions the officer made, only the actions of him jumping onto a moving vehicle and shooting blindly inside. The last to argue was Loretta Petit on behalf of Harris County, Texas.
Thank you, Mr. Chief Justice. And may it please the Court. In the last 15 years, this Court has rejected at least 3 times that an officer's otherwise lawful conduct violates the Fourth Amendment because an earlier split-second decision made a confrontation more likely.
What was at question in the district court was not a question of making a confrontation more likely. It was the reasonableness of jumping onto a moving vehicle and using that as a pretense for using lethal force. After all, expert testimony on behalf of Officer Felix showed that he shot so quickly, Ashton Barnes did not have time to stop.
Properly understood, what Judge Higginbotham dubbed the moment of threat doctrine merely applies that rule. As this Court recognized in cases like Mendez and Sheehan, it is necessary because the Fourth Amendment must be applied by thousands of real cops in the real world without, in the words of Kentucky against King, an unacceptable degree of unpredictability.
So thousands of real cops cannot understand that escalating a situation may bring the reasonableness of their actions into question, but millions of gun owners are required to. It seems the entire argument of the respondents is to place law enforcement above the laws they enforce on the American people.
The moment the officer-created risk theory, which petitioners have continuously pressed at least until their reply brief in this court, is antithetical to that proposition because it invites an open-ended subjective inquiry into the officer's intent that cannot be conducted without the benefit of hindsight. It also, as Mendez recognized, involves tricky questions and fuzzy standards of causation that cannot be easily applied.
Nowhere has anyone asked to look at an officer's intent. In fact, Mr. Zielinski specifically stated that such subjective analysis was not their intent, but the objective analysis of the reasonableness of the officer's actions.
Because the Fifth Circuit has properly rejected that proposition, its judgment should be affirmed, and I welcome the Court's questions.
Because the Fifth Circuit gave them the answer they wanted, Officer Felix in Harris County, Texas, want the court to stop there. But would that be justice? Would that be due process, a judicial process designed to protect the legal rights of the individual? I don't think so. There are 2 aspects of this case I want to comment on. First, the actual question before the court when determining the reasonableness of a law enforcement use of force. Should the court only look at the moment of threat or at the preceding actions of all parties, including officer-created danger? I think the answer is obvious, that the totality of circumstances, including any escalations and dangers created by the officer, need to be considered. If not, then we don't live in a constitutional republic, but a police state where law enforcement can commit any crimes they want with impunity. Second is the question of the reasonableness of Officer Felix's action. Well, there are a lot of facts that need to come out in the courts. Based on what I've read from the Supreme Court case, I've come to the following conclusions. The reasonableness of jumping on the sill of a moving vehicle is questionable, at best. Seeing as it appears the vehicle had just started moving and was therefore going very slowly, I would not automatically find that unreasonable. However, discharging a firearm into the occupied cabin of a vehicle in that situation was most definitely not reasonable. The greatest risk to the officer in that situation was the vehicle running over his foot, not a life-threatening injury, and one easily mitigated by simply jumping back down. With no evidence or probable cause that Mr. Barnes was a danger to others, there was no justification for the use of deadly force. This Dirty Harry mentality of escalating relatively minor situations into an excuse for deadly force not only makes these dangerous officers a threat to our communities, but gives reasonable excuses for people to not trust law enforcement in general. All in all, I would say that both the district and circuit courts made a bad situation worse. We'll have to wait to see how the Supreme Court handles this case. It's been my experience that Justice Thomas tends to benefit law enforcement, to put them above others in most situations. We'll have to see how he comes out when the final decision comes out. But in listening to oral arguments, I kind of get the impression that most of the justices are not too happy with the idea of what Officer Felix doing being reasonable. Does that lead them to say, wait a second, you have to look at the totality, not the fact that the officer was standing on the sill of a vehicle that started moving. So we'll see. It's hard to predict what the court does. And of course, when that decision comes out, well, I'll cover it here on the Constitution Study. But it's just another reason to understand that when you're dealing with law enforcement, remember their training, and even though you may have the right to, it may not be the smartest action to do something that could trigger some of their training into a response that, well, you may truly regret. Now, again, if you want to find out more, go to the website, constitutionstudy.com. Maybe sign up for a mailing list so you can get all of my articles or my news feeds or anything like that. You can also check out my resources that I use when I analyzed this particular case and wrote this episode. Also, I hope you check out like the Patriots program, maybe ask a question. These are all tools and resources for you to use. If you have a question, ask it. I'll do my best to answer it by email. If you're interested in working to help defend people in these situations, well, join the Patriots. We deal with education, communication, and then activation. What can we do to help people whose rights are in jeopardy? You'll find all of that at the website, constitutionstudy.com. Now, if you'd like to support the work that we're doing here, you can always go to the website, constitutionstudy.com/shop, and buy something from the store. That helps. You can even just make a one-time or recurring donation to the work we do here. All of it is greatly appreciated. I don't take a salary from any of this, so anything you do to help pay for this is greatly appreciated. You can also support the organizations that support us. For example, I found this great little course called The Miracle of America. Go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. You'll be taken to a custom landing page where you can read about this great course that deals with our history from the Pilgrims through the drafting and ratification of the Constitution. And it's a great way to see why the Constitution is the way it is. Best of all, if you go to that website, that landing page, you can enroll for a free lesson on God's natural law. So again, just go to constitutionstudy.com/1776 study guide to learn more and to enroll for your free course. Also, consider joining us on Patriot Mobile, America's only Christian conservative wireless provider. Stop spending your money with companies that are supporting those who are trying to destroy our rights. Patriot Mobile donates a portion of their income to NRA, Folds of Honor, Susan B. Anthony List, and others that are trying to defend our constitutionally protected rights. Now, if you go to patriotmobile.com/constitution, you can find all the great plans at decent prices, even check out some of the discounts. But if you use the code Constitution at checkout, you'll get free activation. So again, give it a try. Go to patriotmobile.com/constitution. You can bring your own phone or purchase one there. You'll be helping support organizations that support our rights. And if you use the code Constitution at checkout, you'll get free activation. Most of all, please come back. Please share the work that we're doing here. Take these links, these stories, the videos, the audio recording, share them. Let other people know what's out there. Let other people know what we're doing. Because that's one of the best ways to share our blessings of liberty is by sharing this content. And I hope you come back here and join us next time for the Constitution Study.